is good. This is good, guys. We're engaging. This is good. Okay, so here's your sexy slide. Wake up. It's time. It's time to talk transfer recordation taxes and short sales and REO flipping. A topic near and dear to my heart. Transfer recordation taxes. Yes, you can transfer property from yourself to a land trust without paying transfer recordation tax in Maryland, not in DC. DC is a very investor-savvy town. They have a statute that contemplates specifically this sort of transaction. And they say, no, 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 title company, you're going to collect transfer recordation taxes for that transfer of beneficial interest. It's in the statute, there's no getting around it. Unless you do it completely without the title company's knowledge, which I don't condone, but that's just for you to think about. The transfer recordation taxes, though, if you're transferring a beneficial interest to or from a trust, you will not have to pay transfer recordation tax. Obviously, that's a huge savings for you if you're a wholesaler, you know, or whatever. We'll talk. Actually, why don't we talk? We'll talk about that in wholesaling in just a second. Let me give you an example of a Bethesda deal. I live in Bethesda, which is in Montgomery County. It's a little bit of a drive this morning, so it's southern Montgomery County. It's a very, very high-end type area. I used to live in a Cape Cod there, so not a very high-end house. But properties go for about $550 for just the land. Just the land. $550, $600 just the land. We had a Bethesda deal across the street from me. This guy, I was a listing agent on it, as I told you, I'm a broker. This guy was the worst in terms of clutter. I would call him up and say, we got a showing, okay. And he's like, great, sounds good. Bring on over. And the people would go over. They'd call me up on the way out the door, and I said, oh, well, you know, what'd you think? You know, it's a nice house. It's a nice house. It's, you know, brick, colonial, split level. You know, you're walking up and down stairs, but you got like 5 bedrooms. They're like, well, you know, it would show a lot better if the guy cleaned up his dirty plates and his dirty glasses from the kitchen. He's got them all over the place. He's got junk in the basement, every single level. I mean, this is just, so the property just sat, okay? And it was a good area, nice house, but the guy couldn't get out of his own way to sell it. So I was going to lose the listing, and which I don't like to do, especially on a $600,000 or $650,000 house. So I said to him, well, why don't we buy it from you? And he said, okay, cool. And he said, I owe $575,000. In Montgomery County, if I had to buy that property from him, in other words, if he transferred that property to me, I would have to pay probably about $15,000 in transfer recordation taxes, give or take. That property was worth $660. When we put it back on the market. We bought it, we cleaned it up, we put it back on the market for $660. If I had to pay $15,000, that deal's done. It's blown up. There's no way I'm doing that deal. It's way too tight. So what do? We do a subject to the 575. We have them transfer into a land trust. I give them $5,000 walking away money. We put $10,000 into it. Bam. We're all in about $600. We sell it for $660 in 2 weeks, mind you. 2 weeks. It didn't take any time at all after all the clutter and junk is out, which is what we need to do. We just need to get him out. He had 2 30-yard dumpsters that he needed. Wow. $660, we cleared $30,000. We cleared $30,000 on that deal because we could use a land trust to make it work. It's a tight deal. You know, it didn't sound like a tight deal when you first say, well, you know, there's a lot of money in that, but no, not really, because you've got, when you higher end properties, you got higher transfer taxes. So that was a cool deal that we were able to do just because of the land trust. I had to walk that thing through Montgomery County Land Records Office as well to get that exempt through. REO and short sale flips. So as many people know, REO banks will put a deed restriction in the actual deed that says you can't sell it for 60 days or whatever. Many short sale banks will do the same thing, either in the deed now. Freddie and Fannie will do it in the actual deed. Others will just stipulate in the approval letter that the buyer can't resell this property for 30 days in the case of Bank of America, other 60, 90 days depending on who the investor is and who the servicer is. What are you going to do when you got that sort of thing? You've got a wholesale deed. You've spent some time putting this thing together. and I will tell you, I've negotiated short sales for a long, long time. There are other techniques for short sales, but one good technique, one technique that we've used in the past, is you're gonna sell your land trust. You're gonna assign the beneficial interest in the land trust. Again, think about it like an LLC. You set up the trust at closing. You can tell your end buyer, hey, wait a second, there aren't no lingering liabilities, there's no exposure. Why not? Because we're setting up the land trust. When you sit down to close, it's going to be your trustee. You know, here's a template. I'll give you a template, but have at it. You can do whatever you want with this trust. We're going to sell the beneficial interest in the trust to you, and there's your wholesale fee. It also eliminates transactional funding fees and, of course, transfer recordation taxes. Why? Because you've only got one deed and one HUD. The seller to the trustee of the land trust. It's not ABC, it's AB plus. You're transferring the beneficial interest in the land trust, not the deed, when you make that beneficial interest transfer, right? It's all private, remember? All private, personal property. Yeah? Works great for REOs. Sometimes REO banks will prohibit the use, particularly Freddie Mac will just outright ban the use of trusts. So you have to just know that. They're not unsavvy, they're very anti-investor, and they're aware of this technique. So they say no land trusts. You run into that, can't do a Freddie deal. But it's a lot more economically efficient to do it this way. Why? Because you don't have to pay all that nonsense fees. We'll have a little quick hypothetical. Actually, why don't we just take it real quick right now? Where, okay, let me just show you real quick. So you got a $100,000 acquisition price. You're wholesaling out for $115. So far, so good. ABC structure, that means you buy at 100. You got to pay title insurance, you got to pay transfer recordation taxes, so on and so forth, right? You got to pay transactional funding fees, usually 1 point. Then you got to resell at 115, so you got to pay another set of transfer recordation taxes, some more title work probably, and so on. The AB plus structure, so I estimate that those sort of numbers. Obviously it's going to depend on your deal, which county you're in, what your transactional funder costs, but you're looking at between that $15,000 spread, you're looking at maybe a $5,000 or $6,000 leakage. So you're only getting $9,000 or $10,000. With an AB plus deal, none of that applies. Nothing. One deal from the seller to the land trust, the trustee. You have to keep all your $15,000. There's no transactional funding fees. The B plus buyer is funding the whole thing. It works. The money just funnels the way through, down through the land trust to the seller. Questions on that? This is a very cool point. Yeah.
So you said the seller goes to the trustee.
Yep.
And then at the settlement table.
Yep.
And then you assign your equitable interest.
Yep.
To
beneficial
the
interest.
to the buyer.
Yep. Yep, that's it. Think about it. Think about it like an LLC. I mean, people are more familiar with LLCs, but it's effectively the same, where the end buyer is buying your LLC, right? You're transferring your membership interest in an LLC to an end buyer, and thereby avoiding transfer recordation and all the rest. It basically works the same sort. That's the way I think about it. Except obviously with the deviations that we've already discussed, land trust service and an entity, and so on and so forth.
So you sign the contract that you're going to sign.
Nope. Don't assign it.
No,
nope.
I mean, when you're purchasing the REO.
Yep.
To initiate the contract.
Yep.
How do you sign the contract?
That's the trustee sign it for the land trust as the buyer of the property. The trustee doesn't change.
So then the trustee, none of this should have done on their personal.
The trustee has limited liability. They are only acting in their role as trustee. That's right. They have no liability.
Is this a cash transaction?
This would be or hard money, or it could be private money. You could that could work on all of those. Yeah, it's not gonna work on a retail buyer. Retail buyer, not so much. But if you're wholesaling, yeah, you had a question, right?
Yeah, that was my question, because you might have a novice buyer who might say this is too confusing.
Yeah, that's the objection. That's the objection. Yeah, you're gonna meet with that objection, and you say, look, this could be your. And guess what? Guess what, buyer? I'm actually adding value to you because I'm introducing you to a really cool strategy you're gonna want to use on all of your deals going forward. Let me explain. No liability. You know, there's no lingering past liability. Sometimes you hear that objection. Well, I don't want to buy your LLC. I don't know what I'm inheriting. Guess what? You're buying a land trust that's being formed by you at the table, in effect, by you at the table. There is no past liability. It's impossible because it's being formed by this property. Right? That's one of the biggest objections. And, oh, I want to buy my LLC. Well, hold on a second. Remember the word stacking. We're going to come back to that in a little bit. You can still have your LLC involved. They're the beneficial owner of the land trust.
Can you also do that with, instead of just free and clear properties, can you also do it with a mortgage on the property?
Yeah. Now, whose mortgage are you talking about?
The seller.
Yeah. The seller's mortgage is paid at closing. Has no bearing whatsoever on the structure. You're on the buy side here. So you're buying at 100. The seller has a mortgage on the property of 80. You're paying it off. Or my Bethesda deal, I actually took a subject to in land trust, so we didn't pay
that's
off.
what I'm getting. That's what I'm getting to.
Oh, okay, sure. That's
Can
what we did.
we spread it out over 2 years?
We
and
bought-
do some seller financing into the land trust.
Yep, that's what I did in Bethesda, the Bethesda deal. Now I got them, yeah, pretty sweet. Now I got them comfortable with the subject to because we put a provision in the land trust agreement that said the beneficial interest automatically reverts back to you, seller, if we miss a payment.
Right.
So on the first of the month, guess where we were? At the seller's bank to cut them a check.
Right.
We didn't want to miss any payments. Is this sinking in? Is this good? Is this not good? I mean,
Excellent.
yeah? Okay, all right. You do have to be aware of conservative title companies, and I mentioned Freddie Mac already. There are some short sale approval letters, I will say, that do specify in the approval letter language that says, hey, if you know of any transfer of a beneficial interest in the entity that's buying, you title company have to let us know. You do have to be careful with that, just a warning. Another really cool thing, participations. If you're familiar with participations, what they are is you've got a deal and you want to bring in 5 investors. Okay? You want to bring in 5 people to help you on this deal, basically fund the deal for you. Right? Give them a few beneficial ownership interests. That might work. They might be more interested. They feel more vested, right? You still get a mortgage. You can still get a deed of trust. Still be adequately protected there. Just another technique. Just something else to throw out there. But if you've got a lot of people and you don't want to do an intercreditor agreement because you've got, this person bringing 20,000, this person bringing 100,000, et cetera, then too many intercreditor issues. Just make a beneficial interest. Okay, so the biggest downside of using land trust is the liability. We talked about this, yeah? So here's a bunch of ways where you can mitigate your risk. And I might even argue a land trust might be better than an LLC after you get done with this. Okay, we talked about there's no disclosure of the beneficiaries. No disclosure. Nobody knows who the beneficiaries are except the trustee, right? And you can tell the trustee not to tell anyone. The trustee in land trust law is not an agent, lowercase a. We're not talking about real estate agents here. We're talking about principal agent. If I have an LLC, I have to designate a resident agent, right, to be sued to get service of process. They are not the agents. They cannot receive service of process if the beneficial owner is being sued. So for like a slip and fall case on your rental property, you have to be sued as the beneficial owner, not the trust, not the trustee. If they sue the trustee can say, file for dismissal, judge, I'm not the right party. I can't receive process for the beneficial owner. Well, wait a second, who's the beneficial owner? I can't tell you.
If you're buying the property, your name, if you already own the property, that's what it is. If you already own the property, how do you set up?
You know, if someone does the research and you're already on the property, there's strong indicia that you're probably the beneficial owner, but not necessarily. You see land trusts all the time in land records. That could have been an arm's length transaction. And SDAT's going to say non-arm's length transaction, probably because it's going to be a zero consideration deed, but gonna try. Okay, back to the out-of-state trustee. 1 second, I'll get to you just a second, right here. This is your out-of-state trustee point. You make it even tougher on people who are trying to sue you by getting an out-of-state trustee, by putting in the land records the first initial of the trustee. So M. Hartman, not Mary Hartman. M. Hartman, could be Michael, could be Matt, could be Mary. B. Smith. Williams, Jones. You could have a maiden name. It could be Mary Hartman Smith. So she goes by Mary Smith in most cases, but you're going to say M. Hartman. She produces a driver's license for the title company. When they go to sell the property, they'll accept it. And oh, by the way, you're taking with the Maryland property, and this person's in Missouri.
It can be any person.
Be any person. Any person. Stacking. Did I answer your question? Did I answer your question back here? Sir, you did. I did. Perfect. Stacking. This is a super duper important point. This is what you want to do. This is how you get limited liability with land trusts. Land trust itself, not limited liability. Please understand and hear me again. Okay? The beneficial owner of the land trust can be an LLC. And preventing that, LLCs have limited liability. You get sued, they're not going to go after other assets of the beneficial owners of the LLC. Even trickier point. Land trusts own the property. Beneficial owner is a personal property trust. Because remember, the beneficial interest is personal property. So you can't have two land trusts on top of each other, because a land trust can't own a beneficial interest in another land trust. Land trust can only own real estate. But a personal property trust can own personal property, beneficial interest in land trust. So the trustee of your land trust only knows the beneficial owner of that land trust. That's it. The beneficial owner of that land trust is a trustee for a personal property trust. They're different trustees. You don't let the land trust trustee know who the beneficial owner of the personal property trust is. So if they're ever put on the stand and forced by the judge to disclose who the beneficial owner is, you say, well, wait a minute, Judge, I don't really want to expose myself to some other. I don't care what your doggone contract says. You want to go to jail for 3 days for contempt of court? You're going to tell me who it is. Okay, well, it's Mary Smith, trustee of a personal property trust. That's all I know. Or M. Smith.
Yeah.
M. Smith of a personal property trust. That's all I know. Who's the beneficial owner of the personal property trust? Your LLC. Got it? Pretty cool, pretty cool, pretty cool. Equity stripping, very sophisticated technique. So what you do there, let's say you own the property free and clear. You put a deed of trust with a financial friend. It's always good to have financial friends. Peter Fortunato, big proponent of financial friends, like Spotted Bird. Big proponent of financial friends. People you know, you trust. It's a wink-wink sort of financial friend relationship, right? If you think of somebody in your immediate vicinity, I think all of us would probably come up with somebody, a financial friend. You give the financial friend a HELOC deed of trust. It shows up in land records as this property is encumbered, it's a $100,000 property, it's encumbered with a HELOC of $90,000, $95,000, or $100,000, or $120,000. I don't care. No consideration, no money has actually exchanged hands. It's a HELOC, so it just shows as this is securing up to $120,000 of debt. The actual debt on the HELOC right now, $0. $1. Accumulating interest at 0%.
So guys, what he's telling you now is, when a lawyer goes to look at that document and see that this property is leveraged to the tilt, he's just gonna walk away because he can't sue. This is a way how you hide equity in a property that has equity.
Here's a cool one. You'll like this one. I don't know if anyone's dealt with land records offices, but they're county employees. And we'll just leave it at that. You have to help people who earn minimum wage and don't want to be at their job. Most deeds, most title companies will put in their deed, you know, Mary Jane in all caps, comma, seller or grantor, right? Is conveying the property to Bob Smith, caps, Bob Smith, grantee or, you know, buyer, right? And they'll index the property as being held by Bob Smith because it's right there. It's capitalized for them, they see it. You have to deed these properties into the trustee. We've talked about that, right? They are the owner of the land. Trust is not an entity. What you're going to do is you're going to say, Mary Smith, all caps, seller, hereby conveys the property to lowercase Bob Smith, comma, trustee, uppercase, for the 123 Main Street Land Trust. Guess how that gets indexed? The 123 Main Street Land Trust, without mention of Bob Smith trustee. Just a little swipe at the margins. We're not dealing at this point with the creation of LLCs, right? It's not 20 years ago where this is, you know, a sea-changing sort of event. Right now, you're at the margins. You're doing things that are sophisticated, that are little, right? That protect your interests at practical, day-to-day sort of things that can help protect your business. A couple of little things I think I should just mention. Due on sale clause, presumably people are familiar with this. This is a due on sale clause, so it's in every deed of trust, okay? If there's a deed of trust on record, the lender is going to say, you can't transfer this property to somebody else without either my consent, or I have the right to accelerate the debt, meaning basically I'm going to either foreclose or I'm going to force you to sell the property. It's the due on sale clause, okay? Land trusts, or trusts in general, there's an exemption for the transfer. So if under a federal statute, Garden St. Germain, you can transfer to your land trust, the one that you own as a beneficial. I own the property, I'm transferring to my trust for asset, estate planning purposes. I own the beneficial interest and I occupy the property. That's exempt. They can't call the loan. The lender cannot call the loan in that case, okay? For flipping purposes, that's not exactly our factual scenario, right? We're transferring the beneficial interest in the land trust. So, as a technical legal matter, they can call the loan. As a practical matter, they're never going to call the loan. Number one, they're not going to know about it. They don't monitor land records, as a general rule of thumb, especially if someone's owned the property for a while. They couldn't care less if the loan is current. They don't want another foreclosure. I mean, come on, you got enough foreclosures as it stands. They are not going to foreclose on somebody who is paying on their debt, right? And if you're taking subject to, which is typically the case here, this is when this would occur, right? You're taking subject to, you got somebody else's loan, you're trying to flip that property, typically. So you want to get rid of it fast. So you're going to sell it faster than they're ever going to even know about it, care about it, or even if they know about it and they care about it, by the time they actually take action, it gave you 6 months, you're going to be out of the property by then, even if you're doing a rehab, you know, et cetera, et cetera.
In a situation where you're creating a note, if you say it's pretty clear you're going to sell it in a second, would you say go that route or beneficial interest right into a land trust?
Can't hear him.
Say it, I'll say it.
You're debating he's debating different structures of a seller held second or a land trust. You know, my answer to that is it's going to be case dependent, fact dependent. You know, how you structure your deal is based on your negotiation with your seller. You know, if you can get a 0% seller finance note, you know, hey, that's pretty good. Land trust, as we've discussed, there's lots of benefits to land trust. You know, transfer recordation taxes, for example, that would save you some money right away. You know, whatever. Maybe you combine those things. I don't think there's any necessary intrinsic limitation. You can do a transfer to them, like my Bethesda do. You can do a transfer to the land trust, and then the seller can take back a note. You can combine them. So just be mindful to do on sale. Don't tell me I didn't warn you on that one. But I don't think you're ever going to run into it. It's a practical answer. We talked a little bit during the presentation on land trust versus LLC. Benefits of a land trust: privacy. Obviously, LLC you've got to register, so people aren't going to see you, especially if you got 15 properties all held in the same LLC. No registration, no annual filing report. I would argue, at least an argument could be made, that the land trust might offer you greater asset liability protection. Why? Because it's more judgment proof than an LLC, because of the stacking technique we discussed. You can still have the LLC on top of your land trust, right? So you can still have that limited liability shield, but you've got the added protection of someone's going to have a really horrendous time finding you and suing the right person.
Yeah, I know we're talking about real estate here, but we can also use this process for like automobiles too, right?
That's a personal property trust. Yep, absolutely. That's absolutely correct. We would use a personal property trust because automobiles are personal property. Furniture are personal property. Yeah. Land trusts are used for real estate, the thing that you think about when you think about property. When colloquially we use the word term property, usually you mean a house or land or whatever. That's real property. That's when you use land use. More flexibility. We discussed flexibility with assignments and wholesaling. I think people are a little bit more willing to go with the land trust if you're setting it up and closing as opposed to if you have an LLC. And you know, hey, I got to go down to Baltimore City and set up an LLC. It's going to cost me $300, and then we close. There's could be something that happens in that gap period. The land trust, we're setting it up at the closing table. Transfer tax exemption, conventional financing. Let me just say a quick word about that. It is true that you're going to have a hard time getting conventional financing from Bank of America, SunTrust, Wells Fargo, whatever, using a land trust. They're not going to do it. You can find small regional banks, local lenders, who would be willing to potentially be willing. I've done it. I found banks, so I know it can be done. Some of them are asleep at the switch, and that's how you get it through. But it can be done, and you can always do a transfer after the fact. So your LLC can buy it and transfer to the land trust, or you can buy it and transfer to the land trust, and that's it. This is like the last slide, so I know I'm being ushered out here. Common law land trust is what we've been talking about. The Maryland Statutory Business Trust, I mentioned that we mentioned that earlier. The Maryland Statutory Business Trust does offer limited liability protection. You can do a bunch of series, so you can hold a property in a given series and still have that overarching trust. Whereas with common law trust, you would want to set up a different land trust for each property and then hold the beneficial interest in either a personal property trust or an LLC. Typically, though, the trustee has to be more involved with the business trust. Typically, it's the kind of trust that you think about when you think about, you know, a big estate and the trustee is managing money, a portfolio, whatever, for, you know, the kids who aren't a majority. That's really what's contemplated by the statutory business trust. But in theory, you could potentially use the business trust. You do have an annual report, you do have a filing fee, so it's going to cost you a little bit more money, but you've got the liability issue. Bankruptcy, typically, this is kind of all over the board, whether or not a land trust can file for bankruptcy. Generally, the decisions have come down is whether the trust can be considered a business trust. And there's a bunch of guidelines, I don't want to bore you with it. But most of the time, I would assume that you cannot. Just go into it thinking that you cannot. As a beneficial owner, you can file bankruptcy. But you know, if you employ all the strategies that we've discussed, in theory, you're not going to need to file bankruptcy for one particular property on a given land trust. And we've already talked about the deals. So I appreciate your attention. If you have any other questions, by all means, fire away. But that's my contact information if you want to get in touch. I do tend to be kind of responsive to my detriment. So, in fact, I was responding to somebody just while we were waiting this morning, responding to a question from somebody from another group. So, feel free to fire away. I make money when you make money. We do deals together, so that's the model. I hope you've gotten something out of this. Feel free to email me follow-up questions. I'm available for your benefit. And again, I thank you for your attention and the invite today.
Give us a big hand, guys.